Good afternoon, Judge Gorven.
Good afternoon, Chief Justice.
How are you, sir?
I'm very well. Thanks very much.
Thank you. You interviewed for this position before.
I have many times.
And now it's something to feel, it's nothing to feel bad about, sir. Just give us an added perspective of how all these experiences, including the additional acting stints, have prepared you for the SCA.
Yes. Well, I have, over the time I've been in the courts, produced 53 written judgments, reported judgments, of which 18 are in the SCA. The last few years, quite a number of them. I have served in the SCA for a total of something like 3¼ years, if you add all the stints up. And during that time, I have established warm relationships with colleagues there, to the extent that I feel there's a sense of mutual support, and I'm technically able to write judgments, deal with the matters, stand alongside people who might be having some difficulty getting their judgments out. It's a bit of a pressure cooker situation there, because every term there's something like 70 appeals that are heard, and if you don't get all those judgments out and you carry through into the recesses, you're meant to be now preparing your next lot of 70 appeals for the following session, and it's very, very difficult. So it's the kind of court where mutual support is absolutely crucial, and where I feel, having had that sort of service, I'm able to advance that to my colleagues there.
Over to you, President.
Thank you, Chief Justice.
I'm sorry again, President. Let me apologize to you again. The same mistake. Colleagues, may I have your name, please? Commissioners, may I have your names, please?
Nyambi, Matonsela,
Lucas, Schlemmer,
Barnard,
Tepe,
Thank you. Over to you, President.
Thank you, CJ. Good afternoon, Judge Gorven.
Good afternoon, President Meyer.
Well, here we meet again. Let me start by thanking you for making yourself available yet again, and just explain that you do so because of pressure from colleagues at the SCA who keep begging you to do that when you fail. Well, as I said last time, in your 2019 interview, the evidence of your competence, your efficiency, your diligence, your integrity, your collegiality, your contribution to the transformation of the professions and the judiciary, and your community work is all on record, and I won't ask you any questions on those areas. I just want to raise a couple or so issues with you. One, which we talked about last time, your age. You turn 67, I believe, in a week, although one wouldn't say just by looking at you. What contribution, if any, do you think you may still make in the few years you have left in active service? And should advanced age be an issue in a court such as the SCA in any event?
Well, I think age can be a two-edged sword. I think having some advanced age with experience allows you to have had extra additional experience and to make a contribution. Having had the time at the SCA where I have had, I can hit the floor running and make a contribution. In the more than 3 years that are left to me, I will get involved, if I'm in the SCA, in approximately 180 judgments still. So there's a lot of work to be done and achieved within the 3-year period of time. Add that to my 3¼ years that I've already served, and one has the kind of experience that I think can stand alongside of people who might have been appointed recently and not quite yet found their feet, or dealing with areas of law haven't been exposed to for whatever reason. In 2019, the 5 judges whose vacancies were filled had between them 93 years as judges. In this occasion, the 5 judges whose places are to be filled have had a total of 92 years experience. That's
It's actually
40%.
97.
That's 40% of the court that's been changed in the last 2 sessions, and it leaves something of an experience gap, which I think I can fill. And it's a good time, 3 years or so, to stand in the gap, to allow those people to get going, find their feet, and move forward.
Well, you've given us your impressions of the court. What, if anything, do you think we could improve in the way we do things, and how so?
The way judgments are allocated might be looked at to have a slightly more even-handed approach. One might introduce, very often straight after a hearing, for those who don't know, a conference is heard by the panel of judges who go through the arguments that have been advanced and give a prima facie view of how they think the judgment should go and what it should deal with. It might be helpful to have another interim conference before the person has to actually produce a judgment. Once the dust has settled somewhat and you've been able to go back and research areas of law which might have been raised in argument that hadn't been fully dealt with in heads. So that might be one area of improving the performance of the court. But it's, as I say, it's a high pressure court, and things need to get brought out quite quickly.
Well, regarding conferences, I can just point out that it's always been open to colleagues to indicate, even after the hearing, if they're not ready, they still need time to let the issues marinate before they venture their opinion, and ask the presider to call a conference, an interim conference, or whatever you may want to call it, before the final one. Maybe we just need to spread that that message more emphatically. But I just want to hear more about your first point, that we could improve on the way we allocate work. What exactly is not quite right now?
I wouldn't say there's not necessarily quite right, but when presiders allocate judgments, there has been in the past something of a perception that maybe the presiders are somewhat cherry picking judgments, which are interesting and maybe reportable. And it might be that there's a more of a melting pot system that can be utilized. I'm afraid I don't really know exactly how I'd go about that, but that might be an area where perceptions of not being allocated, as it were, interesting or challenging or whatever it might be, judgments can change.
Yeah. Well, thanks for that point taken. But again, it's something DPPZ and I and the rest of the presiding judges actually have been working very hard at over the past while. First, to ensure that, unlike in the past where you had people ending up not having any judgment to write, when there were people who had maybe as many as 4, to themselves, everyone, especially the acting judges, who we want to give as many opportunities to prove themselves and ease into the culture of the court as much as possible, they get their fair shake. I'm just looking at the May 2021 case allocation now, and all the acting judges, each among them have 2 judgments to write, except 2, and that's it's Judge Patswane, who's brand new, and I thought there are reasons behind that, and Judge Ledwaba, but we know how we'll make up for that in the petitions that keep flooding in, and in the past term he had got more than others. But I want to point out that even 4 permanent judges including the deputy president, have one judgment to write to themselves to make way for the acting judges. Now, about the quality of those judgments that people get to write, that's something that we've sorted out. And one just needs to go to the website and check the judgments that are, the appeals that are there, and watch who will get to write the judgments in those matters, and junior colleagues and acting judges, especially Black judges, because that's where issues always around. They get a fair chance to write meaningful judgments and get enough chance to write as other colleagues. So I think we are on the right path to addressing the issues you raised. Is there anything else?
No, and I want to just say that I do recognize that that situation has changed, and hopefully those perceptions won't last as a result of that. It is quite clear that there's a much more equal distribution, and those interventions have been very useful.
Well, lastly, I just want to add to your list of judgments. One I picked up yesterday. It was delivered yesterday. Tramo Property Group against Poslura Square CC. And the remarkable thing is that it was heard exactly a month ago. And as with all your other judgments, it was the final judgment was delivered 4 weeks later, despite all the pressures of the SA. And that actually is one of the reasons you keep being invited to come back, time and time again. Most often at very short notice where we have an unexpected gap. And thank you for that. And thank you for supporting.
In fact, that judgment would have been quicker, but one of the judges was indisposed in hospital for a while and wasn't able to make comments on the judgment.
Well, thank you, Judge Gorven. Thank you, CJ.
Thank you, President. Honorable Nyambi.
Thank you, CJ. Afternoon, Judge Gorven.
Good afternoon.
I'm just going to ask one question. As you have quite correctly indicated that not so long ago you were here, probably anything that you think is significant that happened between then and now that we must consider when dealing with all the candidates that you might wish to share with us. Any development that is more than relevant and significant in terms of the position you have applied.
The only relevance is that I have acted again in the Supreme Court of Appeal since then, and gained additional experience and formed deeper bonds with colleagues there to be able to deal and work with them at the time. And I've also had lots of personal messages where people have taken the trouble to contact me, colleagues in that court, to say that they are very pleased that I'm appearing and they would very much like me to be on the court. That's the only developments I can think of.
Thanks, Judge Gorven. Thanks, CJ.
Thank you, Honorable Nyambi. Commissioner Madonsela.
Thank you, Chief Justice. Judge Gorven, good afternoon.
Good afternoon, Commissioner.
The question that I have, one question for you, and you may or may not want to answer it. We have 5 vacancies for the SCA, and one of the applicants is of the same position, in the same running for the position, is a judge who is white, like you, from KZN, and who comes from the same bar that you practice from. I know this because we come from the same area, and who may very well be your friend. You practice together in Pietermaritzburg. Why can't you just settle this issue amongst yourself and say one of us should go and I will support you? I mean, it has happened in the previous, we're interviewing some candidates before you, and they seem to, I got a sense that they've settled amongst themselves as to who's going to take which position, who's going to apply for which one. Is it not possible to make our lives easy? You or him? You
Yes.
know who I'm talking about.
Yes, I do. Yes, and we are friends and colleagues. So, but I think we probably both thought that we might bring something a little bit different, which the Commission would want to consider to the situation. And I certainly have no reason to ask him to stand back, and I presume he felt he had no reason to ask me to stand back. I don't know if I can give you a better answer than that.
Thank you. Thank you, Chief Justice.
Thank you, Madam Sela SC. Honorable Lucas.
Thank you very much, Chief Justice. Good afternoon, Justice Gorven.
Good afternoon.
I see really you are one courageous person to come over and over again. I hope after this, it will be third time lucky.
Thank you.
No, I was going through some of the submissions that you have made, and you are aware that in South Africa we've got a second pandemic of gender-based violence, particularly against women and children. And I've seen that you have adjudicated on some of the issues. But in our findings that we did after a countrywide project of Parliament on the Women's Charter, one of the issues was that we found that particularly the women of South Africa felt that the courts doesn't show enough compassion with what they are going through. I would love to understand what is your take on the issues that that you have been dealing with, and what is your view around the whole issue of what is going on.
Thank you. I don't know that the courts are dealing sufficiently sensitively with it. I think victims are often not dealt with a great deal of compassion right from the first instance when they want to report an incident. And I think courts can do better. I think measures have been put in place now with the way people can testify in camera or by remote hearings, which might ameliorate things somewhat. I have to say that my own experience of matters like that is at this stage, both in the High Court and the Supreme Court of Appeal, only the experience of reading on paper what other courts have done in respect of these matters. And I think so often the prosecution doesn't utilize all the evidence that's available. It's in a situation where, by its very nature, there is almost always only one single witness. And as a result, one has to, as a prosecution, bring to bear whatever other evidence you might have, such as DNA samples and collateral people who've seen movements in the area and so on, to try to buttress that version so you don't have a he said, she said kind of scenario. There should also be massive sensitivity to the fact that victims of gender-based violence and violence against children are suffering a second time when they come before the court, and so often go through that and relive that same trauma, but it almost deepens perhaps the wounds which have been suffered. So I do think courts need to be very, very sensitive and very welcoming of those kind of people and the evidence in situations such as that.
Thank you very much, Justice. Thank you, CJ.
Thank you, Honorable Lucas. Prof.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Professor.
I had a discussion with the JP of the Gauteng division this afternoon, and I would just like to hear your opinion. To what extent does the argument of legal counsel lead to good motivated judgments?
It makes a huge difference to have really competent legal counsel argue before you. Without that, the judge is left more or less to their own devices and to their own research. And it's very, very difficult to make sure that that research covers all the angles. That's one of the reasons we have the adversarial system, because you hear properly prepared, well-motivated arguments from both sides, and you're, as a result, shown all the angles, or as many angles as possible, hopefully, in any particular case. So competent argument makes a huge difference to the outcome of good judgments which stand the test of time.
Thank you, Judge. Thank you, CJ.
Thank you, Prof. Commissioner Barnard.
Thank you, CJ. Good afternoon, Judge Gorven.
Sorry, I can't see you. Oh.
What would you say to allay perceptions? I want to take the matter just from a different perspective, that you are given your prosecutorial background, that you are more of a prosecutor's judge, and that might to some extent compromise the rights of innocent accused. I'm just having a look at the judgments that you've shared with us, and some of the comments, and for example, the intermediaries, where there are rules about how they should be dealt with, and despite non-compliance, the evidence is still upheld. But adding to that, for example, State versus Scott, where two of the accused convictions were later set aside on appeal, successful appeal, and the accused number one, that was also the sentence was made to run concurrently. What would you say to allay those fears or concerns?
Well, I was a prosecutor for 2 years. I was defense counsel for 20. So there's no bias, and my most recent experience as counsel was in the defense side rather than the prosecution side. And judges sometimes get things wrong.
Thank you, Chief Justice. Thank you, Judge.
Thank you, Commissioner Barnard. Commissioner Tsepe.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
CJ, Justice Meyer asked one of the questions I wanted to ask, and it was answered promptly by Judge, and thank you very much. It related to the speed with which you deliver your judgments, and that's quite impressive. The one issue I wanted to talk about, Justice Meyer touched on it as well, is your contribution to transformation. I see on your CV your contribution, particularly of training of to the bars and to the Black Lawyers Association. What I wanted to find out is what has been your contribution on transfer of skills and training of other judges, both in the High Court where you are appointed and in the SCA. Although you're not appointed permanently, you've been acting there for quite a while. Thank you.
Thank you. I've made it my business when acting judges come to the High Court and I'm sitting to stand alongside them to find out when they're in court and what matters they might have, and to offer my services. Particularly where something like the motion court, which is a very high pressure kind of court situation, a person's going to sit for the very first time. I have invited acting judges to sit with me in my motion court. I've given them the files to go through. When they've gone through it, we've gone into court, and the person, she sat next to me, the acting judge, on occasion, many occasions, right through the motion court proceedings. And then afterwards, we discuss what she would have done better, what I could have done better. And so there is a skills transfer directly there. As regards the other skills transfers, I have on many, many occasions been asked, having offered my services, to look at draft judgments to see if their style could be improved, or rather that, that it all was going logically and so on. I have always made it my business to offer to assist anyone who might be having some difficulties with things, whether it's in the SCA, any judge, or in the local High Court. And I've been taken up on that. So it's wonderful to be able to do that. But of course, by its very nature, those aren't really formal proceedings. It's always an informal skills transfer process.
Thank you, Judge. Thank you, CJ.
CJ, sorry, Klaba.
Thank you, Commissioner Tsepe. Honorable Klaba.
Thanks, CJ. Good afternoon.
Good afternoon.
Yes.
there was a concern raised regarding the speed with which judges leave the division for a senior position in another in a higher court or a superior court, and they come in for less than 24 months or 2 years, and then avail themselves for appointment to a senior position. Is it not the same as considering a person who only has about 2 to 3 years before retirement? What is your comment on that? Thanks.
No, I think it's the opposite, actually. I think if you've served a lengthy time in the division, you're definitely more likely to make a good contribution within an appeal situation. It's a very good thing, you know, for appeal judges to have sat as judges in the High Court and perhaps below as well, because when you sit as a judge of appeal, it's very, very easy to take an armchair view. And the professor asked me a question about submissions and so on. In the High Court, your level of representation and the level of submissions often isn't as good in the Supreme Court of Appeal. And it's very easy for an appeal judge to sort of somewhat even denigrate judges of first instance when they haven't had the assistance they've had or the opportunity to read a prior judgment from that court. So I think the experience that one has is a good thing. It means that for the time you have on the appeal court, you can make a genuine, real contribution. And of course, having had 3¼ years of experience already, I believe I'm more than ready to make a very good contribution in an appeal court.
Thank you so much.
Thank you.
Judge, thank you so much, CJ.
Thank you, Honorable Kwaba. Thank you very much, Judge Gorven. You're excused.
Thank you very much.